Good afternoon, everyone. Happy to have all of our Zoom participants and Facebook family and friends with us today for another special edition of our virtual lawyer project, Know Your Rights virtual legal clinic sessions. So again, I'm Jelena Small, Director of Parent and Family Programs with Say Yes Buffalo, and happy to have with us our Say Yes Volunteer Lawyers Project Coordinator, Emily Alvarez, who will be introducing our presenter for today's session.
Hello, everyone. Thank you for joining us in today's session, our Know Your Rights session. Today, I am presenting our attorney, Lori Roman Genovese. She will be doing the presentation today. Lori is a staff attorney at Volunteer Lawyers Project and the director of the Erie County Family Court Help Desk. Lori practices in Erie County Family Court and represents low-income grandparents and siblings in visitation cases and non-parents in custody matters. Since the pandemic began in March, Lori and staff attorney Vanessa Geit have offered over 900 family law consultations to low-income clients who called VLP's Family Court Helpline. Prior to joining VLP, Lori was in private practice, focusing on family law, was a member of the assigned counsel panel, and an attorney for the child. Thank you, Lori, for today's presentation, and I'll pass it on to you.
Thank you, Emily. I apologize, I was muted. I want to thank you for all your work and help getting this presentation ready for today. And I want to send a special thank you to Galena and Nikki from Say Yes and all of the people at the Say Yes program for sharing Volunteer Lawyers Project's mission to bring access to justice to people regardless of their financial ability to pay for an attorney. So thank you all for allowing me to speak today and hopefully help some people. As Emily said, I've devoted my practice to working with families in family court. Now, typically when you think of family court, you think of it as a court for parents. You think of parents going to court for custody and visitation issues because they're not getting along and they want the court to give them direction as to how they can handle the raising of their child. But in reality, the Family Court Act, which is the rule book for the judges and all the people working in family court, extends the rights past parents and into relatives and other people in some limited cases. So today I want to talk about those limited cases and go into whether or not you have rights or what they call standing to go to court and ask the court for help in your particular situation. We all know how important grandparents and family members are in the lives of our children. And as parents, usually that relationship is natural. But when something happens and something goes wrong, there are times when family court can help you maintain that relationship. So I want to advance the slide, Galena. There we go. So the first thing I want to talk about today is the terminology that we're using. So we're talking about custody and visitation. And I know it seems like it makes sense, but the words are a little confusing. Custody doesn't refer to who has the child or who has the child at that time. Custody refers to decision making, and again, not access with the child. Now you might hear the term joint custodians, or he has joint custody with the mother. And joint custodians means that they share decision making. When we talk about decision making, we are talking about major decisions. Which school does the child go to? Which religion are they raised in? Maybe the child needs ADD medicine or needs special counseling. Is that a right answer for this child? Joint custodians have to work together to come to that decision. I want you to know that the courts have a preference, especially with parents, for there to be joint custody. They don't want it all to fall on one person's shoulders because they realize how important these decisions are in the life of a child. Now, if you're a non-parent or a relative or someone close to the child who is able to get custody of the child, you may very well have joint custody with that child's parent. You could also end up having sole custody. And sole custody means that you get to make those decisions on your own. You can make that decision without having to consult the other person. Sole custody isn't preferred, especially again with parents, and is usually limited to cases where that other person isn't available. Maybe if you're a grandparent, mom and dad just have too many issues and aren't available to help you make decisions for the child. If it's a mom and a dad situation, maybe one person's incarcerated or lives in a different city, or maybe there's a huge history of domestic violence and you know that there's no way that the custodian, mother or father, can have a meaningful discussion with the other parent. So there are limited times where the court does allow for sole custody. But again, the preference is for joint custody and have the people that love this child work together to make decisions. And then you might hear the term residential custody or the child resides with, and that refers to who the child lives with. And the residential custodian is the person who will have the ability to have the child live with them, to send the child to school in their school district, and also get the benefits that may be bestowed upon the child by whether it's by the government or some other way of getting benefits for the child, like child support. So you could have joint custody with someone and be the residential custodian and be entitled to child support and benefits to help you while still sharing that decision-making with the other person. So the other thing we're going to look at today, and what we're actually going to look at first, is visitation. And visitation is what some people confuse with custody. Visitation is time spent with the child, and that can be all types of amounts of time. Visitation can be extended overnight access. I mean, there are parents that have week on, week off. It can be daytime access. It can be public access where maybe you don't have proper housing or the person doesn't have proper housing for the child, so you see the child at a park or playground. It can be supervised access, so you may end up getting custody of your grandchild, and the child, your child may end up getting supervised access with you where they can spend time with the child, but you need to be present. And then there's also the most limiting supervised agency access. And those are the cases where the court is really concerned about the child's well-being in that person's presence and maybe has the people go to a place like Catholic Charities once a week or once every other week for an hour with someone who's trained to deal with access, overseeing that access or supervising it. Now, when we look at visitation, we don't typically talk about decision-making because decision-making in visitation cases usually is minor decisions. So the child's over at your house and you pick the bedtime and you pick what they have for dinner, because those are everyday decisions that should be made on the part of the person who's exercising their visitation. Now that's true with parents, but as a non-parent, you really need to be careful with that, and you'll figure out, and you'll understand rather, why that's the case as we go on with the presentation. Non-parents must be really careful to follow the parents' wishes. And as we'll discuss later, one of the main reasons to not get visitation or to have trouble obtaining that order or losing your ordered visitation is if you undermine the parenting of the parent. So if mom and dad say, we have this child on a diet, we think it's medically necessary, we don't want them to have any cookies or cake. And I, as a grandmother, every time my husband's granddaughter comes over, the first thing I do is go to Wegmans and get her some big fancy cookie. But if mom and dad say, I don't want that, I need to follow that rule from them, because I don't want to undermine their parenting. Because if that child goes home and gives that parent trouble because grandma says they can play video games and grandma says they can stay up late and grandma says they can have cookies before dinner, that parent might come back to court and say, I want this visitation stopped because I have trouble parenting because of the actions of the grandmother. Now, is it always that trivial of a situation that could cause a parent to stop visitation? Of course not. But if it becomes a pattern and it's a situation where the parent feels like they can't do their job with their child right because they believe that the grandparent is undermining, that's not an issue you want brought before the court. So those are the two terms we're looking at. We're going to start with visitation. And this goes for custody as well. Before you go to family court, you need to be able to ask the court to order you relief. And the court doesn't really have that decision. And the judge doesn't get to make that decision. It seems like it. They get to make the decision if they're allowed to, but they don't just get to automatically say, yeah, I'm going to hear your case. No, I'm not going to hear your case. They have to look at what the law allows them to do. And the law, again, is the Family Court Act. So the Family Court Act can give legal standing, or does give legal standing to some people. Standing refers to the ability of a person to bring an action in court based upon their legally protected interest in the matter. Now that's true for all kinds of courts, not just family court, but in family court, it's, do you have a protected interest in this child? Legally protected interests for matters in family court are defined in the Family Court Act. And although anyone has an interest or the ability to ask for custody of a child in family court, the Family Court Act only recognizes a legally protected interest for visitation for parents, grandparents, and siblings. So even if a judge might want to order access to an aunt or an uncle or a cousin, they're not allowed to, because the Family Court Act says this is limited to parents, grandparents, and siblings. And I know some of you right now are thinking that is so unfair. And when I give the scenarios coming up soon, you'll feel that even more. And I get that because I work with clients every day on the phone and at the family court help desk in person. And I see people who truly love a child and would be a great influence in this child's life. But the Family Court Act just doesn't allow them to have visitation. But realize that as desperate as that might sound, New York State has some of the most liberal visitation rights for non-parents. Most states have the attitude that if a fit parent says, I don't want you around my child, it doesn't matter what their reasons are. It doesn't matter how good of an influence you could be for that child. They won't recognize your right to see the child. So at least in New York State, they say, you know what, I think grandparents and siblings, in addition to parents, there may be a case where you should have visitation with the child, even if the parent objects. So what does that look like? And I want to advance. Thank you. There we go. I'm going to use 3 different scenarios before we get to grandparent and sibling visitation, just to give you underscore just exactly who can come to court and ask for visitation. So in scenario 1 and 2 and 3, just for your knowledge, these aren't actual cases of people I've represented, although I do represent many people in family court on visitation matters. And they're not even cases that I took on the phone. It's more like a composition of different types of cases that I've had to handle and different types of situations where we had to tell the person they didn't have standing to ask for visitation. So in scenario 1, mom has lived with her 2 young children and her older sister since the children were born, and the sister was a resource to these children. Mom tragically passes away and the children move in with their father. Dad does not like or get along with mom's sister and refuses to let the children see her. Can this aunt get an order of visitation in family court? And the answer, unfortunately, is no. Does any set of facts change this answer? And again, unfortunately, the answer is no. But what if there's no maternal grandparents or half siblings that would have standing? And basically the child will be lost to the maternal family unless his sister gets visitation. Still, the answer is no. She can ask for custody if dad is not doing a good job raising the children, but if dad is doing a fine job taking care of the children and there's really nothing wrong with him, she's forced to resort to getting along with the father and trying to work with him because the court, it's not they don't want to help her, they're not allowed by the Family Court Act to hear that case. In scenario 2, another similarly sad kind of outcome, a man marries a woman with a 1-year-old child from a previous relationship. The child is now 13 and very close to his stepfather and considers him to be his dad, even though he was never legally adopted. Mom leaves the stepdad and files for divorce. She refuses all visitation. Can he get an order of visitation in family court? I mean, think about it. He's been acting as this child's father for 12 years and the child loves him, but he didn't legally adopt the child. So the answer is no, even if the biological dad's not around. If there is a half sibling, can he file on behalf of that half sibling? So say him and mom had a child together after and ask for visitation for that child. Well, he could, but most likely that child is already seeing their sibling through mom. So this isn't a matter of I want to file for more visitation for the half sibling. It's that the half sibling isn't getting visitation and I as their dad want that to happen. And even if he wasn't getting visitation with mom, with the sibling through mom for some reason, there's no guarantee that if he did get an order of visitation ordered that he would be part of it. It would be just for the sibling. Okay, and then scenario 3, which is all too common. Child Protective Services removes the child from mom and dad's home. And since no one in the family takes custody, the child goes into foster care. After a few court proceedings, it becomes clear that mom and dad are going to lose their parental rights. There is no living grandparent and no other siblings. Can anyone in the family get an order of visitation in family court so that that child can still know their parent's family? And the answer again is no. If you're not a grandparent, and we're not talking great grandparent, we're talking grandparent. If you're not a grandparent or a sibling of the child, or a parent of the child, or a legal custodian of the child, there is no visitation. So what can a person do in this case? If they're the family member and they want to have visitation with the child, the only thing they can do is in the very beginning, when this case first comes to court, is ask for custody of that child. And we'll talk about that more. I don't want it at all in this presentation. So if it sounds that way, please don't take it that way. I don't want to disparage foster parents or the foster care system. There are many times when it's the only the only resource for the child, and these are loving people who want to care and raise a child. But once a child goes into foster care and they're there for a while, they could easily be lost to the actual biological family. So you really do need to have someone in the family or someone close to the family step up and get custody, if possible, before or as soon as a child goes into foster care. So the next slide, here we go. Did it go backwards? There we go. So what about grandparents? I just said that grandparents have a right or have the possibility of having standing to ask for visitation. Is that always the case? Do grandparents always have standing to ask for visitation? And the answer to that is no. It depends on the situation. So there's two typical situations in the two categories that fits into, and we could talk about how each of these categories is able to get standing to ask the court for visitation. In the first scenario, a grandfather's son passes away and the children's mother refuses to let the grandfather see the children. Can this grandfather file a petition for visitation? So does he automatically have standing to ask, not necessarily receive, but ask for an order of visitation? And the answer is yes. The Family Court Act recognizes what happens when one of the children's parents passes away. So it says that if a child's parent no longer has two parents, if one of their parents passes away, the grandparents have automatic standing to go to court and ask for an order of visitation. But what if both parents are still alive? So let's use the second example. A child's parent gets upset with, parents get upset with the grandmother and refuses to let her see the child. Can this grandmother file a petition for visitation? She can file, but she's going to have to prove standing. She doesn't automatically have it. So how does this grandmother obtain standing? And I believe that's on the next slide. Yep. If the grandparent wants standing and the parents are alive, the court, before they get into whether or not it's in the child's best interest to spend time with this grandparent, they need to see that the grandparent has what it takes for the law to say that they can ask the court and have standing. The first thing is they have to show is that they have a close relationship with a child or have tried to have a close relationship with a child, but the parents are preventing it. So, mom, when she was with her last boyfriend, he liked her. He liked maternal grandma, and she was helping mom all the time, babysitting. The child spent frequent overnights. She was very close to the child. She gets a new boyfriend who grandma doesn't approve of, and mom says, you can't see the children anymore. And dad doesn't want to make waves, and he's like, if she doesn't want you to see him, I don't want you to see him either. In that case, you'd be able to establish that you had a close relationship with the child. Or another situation would be maybe mom and dad just had the baby and they won't let you see the baby. Well, you didn't have a chance to establish a close relationship. But if you can show that you've tried and you've asked for visitation and then go to the next step to filing the petition, then you can show that but for the parents, you would have had a close relationship with the child, and that would help you get standing. But just showing that you had a relationship with the child or that you tried really hard to have a relationship with the child isn't enough. The second part of this test is that the parents don't have a legitimate reason to deny visitation. So if they have a legitimate reason, and one of the things I talked about before, which comes up is, she undermines my parenting. It's not that we don't get along, but she takes her animosity towards me and makes my kid not like me. And I don't want to have to deal with getting my kid back on track every time they come home from seeing grandma or grandpa. But if that's not the case, and it's just that, I never talk about mom and dad when my grandchild is here, but mom and dad are really angry with me, and maybe it's I gave money to their sibling, or I don't like her new boyfriend, or whatever the reason is, but there's just this animosity for no reason other than something personal to the grandparent and the child. That's not enough to stop you from having visitation. So the court case law says really clear, mere animosity is not enough, because if people were getting along and liked each other, you wouldn't have to come to family court, just like parents. But so if you're in court, chances are that you're not getting along with the children who are the parents of the child, but it's got to be more than just the fact that the two of you aren't getting along or the three of you aren't getting along. Once the court determines that there is standing, so you've lost your child sadly, or the child only has one parent and you're going to petition in court, or you have a close relationship with the child and you allege that there's only animosity is the only reason why you're not able to see the child, the court will then take your case and then start to look at whether or not it's in the best interest of the child to spend time with you. They look at some of the same factors. They look at the relationship between the child and the grandparent. The child will have an attorney. Every child in family court automatically gets an attorney. I used to be an attorney for children, and I just love doing it. The kids are are wonderful to work with, but it's a huge responsibility because as an attorney for the child, if the child's old enough to make a knowing decision, and there's no age for that, it's not like, well, the child is 12, they can make a decision, the child is 9, they can't. If you can tell when you're speaking with them as the attorney for the child, you determine that this child understands and gets it and knows what they want, you have to advocate their wishes unless it's going to put them in ultimate or intimate immediate harm. If it's not going to put them in harm, if they say, I want to see grandma, then you go to court and you argue for them seeing grandma or grandpa. If they say, you know what, grandma and grandpa, they're really nice to me, I just don't, I'm 13 years old, I want to hang out with my friends on weekends, I don't want to have to go see her or him, then that attorney has to advocate for that. So the children really kind of steer the ship for the attorney for the child, not necessarily the court. If the child, however, doesn't have that capacity, then it's up to the attorney for the child to try to determine what they think is in the child's best interest. And like I said, the child will talk about what they want and let their attorney know, and the attorney will advocate for that. It doesn't mean that that's what's going to happen, but it does play a role in the court's final decision, especially with grandparent visitation. And then they'll look at the fitness of the parents. Again, I said in many states, and including New York State, there is this presumption that a fit parent or fit parents can tell whether or not they have the right to make the decision as to who their child associates with. They're a fit parent. They can make that decision. So if the parent is fit, that's going to give some pause to the court. So if there is a problem with the fitness of the parents, if there's a history of mental health or drug use or something that you think is causing the parent to not make a fit decision, maybe they're in a domestic violence relationship and that's preventing them from allowing the access, that could definitely help your case. And then finally, whether the parent undermines the child's relationship with their parent, or whether the grandparent undermines the child's relationship with their parents. And we talked about that before. If every time the child is with you, sometimes it's hard not to say things, but you say things you shouldn't to the child, or maybe you don't follow the rules the parent sets down because you think they're unreasonable and it's your time. And the parent can demonstrate that to the court, or you more appropriately, you can't demonstrate that's not happening to the court, then you will not get visitation. And then any other important factor. They'll look at you as the grandparent or the sibling and look at your history. Do you have a history where CPS has removed children from your home? Are the parents alleging that there's something wrong with your fitness? And if that's true, you're going to have to overcome that hurdle too. So how can you prove your case for standing in best interest? I mean, I just said that you're going to have to show them that you had a close relationship, and you're going to have to show that you don't undermine the parents. So what kinds of things can you do to show that to the court? Because the burden's on you to show the court that you have standing, and then the burden's going to be on you to show the court that it's in the child's best interest to be with you. So things I've used in court that have been very successful are photos. I mean, if you look at the photos and there's a long history of frequent visitation with the child, and the child's happy and in grandma's arms or on grandpa's lap, and they're all playing together, and you can show that through photos, that says a lot to the court. Text messages, if you're attempting to get access with the child and you send a text to the parent, you're going to want to save whatever was said before and whatever was said after, because the court doesn't want to just see your little blurb that benefits you. They want to get a good feeling for the whole communication between the parents and the grandparent. But text can be used. You want to document your attempts to see the child. A good way to do this is to keep a journal that you write in immediately when things happen. So maybe you get a call from mom for no reason on a Tuesday saying, you can't see the child this week because I'm upset that, once again, you favor my sister over me. Well, then you're going to pull out a journal and write the date and the time and put that down as it happens. If the parents simply won't let you see the child, don't just walk away. Send cards on their birthday, send gifts to the child. It's not about your fight with the parents, or the parents' fight with you isn't about the child. So you have to make sure that seems clear to the court. You don't want to harass the parents and send several texts and be bombarding them and telling the child your parents won't let me see you. But you do want to not walk away. I've seen cases which are really sad where, especially when someone loses a child, so maybe you've lost your son and the children's mother is just a big pain to deal with, and you keep trying to see the grandchildren and you keep saying no, and you just walk away for a year, and then you're on Facebook and you see a picture and you think, this isn't fair, I want to be with my grandchild, and you file, then you may be prohibited from acting or from asking the court for an order, because they may say that you don't have standing because you haven't closely bonded with this child because of your lack of follow through. one of the best ways to follow through if you are being denied visitation over and over is to file a petition in family court. So how do you go about getting this court order for grandparent visitation? I just said what you need to let the court know, but how do you actually get in front of the court? Well, you need to file a petition in family court, and to know where to file, the first question you have to ask is, where does this child live? Is this a child of New York State? The way courts determine what the home state is of the child, and home state just means which court is best suited to hear the case, is where the child's lived for the last 6 months. So if your grandchild lived with you and family members in New York State up until March, but then in March moved to Pennsylvania, that's more than 6 months. So Pennsylvania is now the home state of the child, and Pennsylvania has different laws about custody and visitation. So if the child has been living in New York State, the next question is, what county does the child live in? Now, technically, petitioners are allowed to pick their county in New York State that they can file in if the child is a New York State child. That's technically. So if the child lives in Chautauqua County, but you live in Buffalo, you technically could file in Erie County, but the county does have the right to transfer the case, especially upon the request of the parent, to the appropriate court. And the reason is convenience of the court and the ability of the court to get the information they need. If all the evidence is in Chautauqua County, the kid's in Chautauqua County, the attorney for the child should be in Chautauqua County and able to really spend time with that child. So technically you are able to file in any county, including your county, but it typically is best to go ahead and file in the county that the child resides in. So where do you get a petition? COVID has made this more difficult. Obviously, before COVID, up until March 17th, I was at the Family Court Help Desk on the 4th floor of Family Court. People could go up, grab their petition from the petition processing, and if they had questions, come and talk to me or one of the other attorneys we had working to have help filling it out. But because of COVID, the court's trying really hard to eliminate foot traffic, and you can obviously understand why. So at this time, you should not go to the courthouse unless it's absolutely necessary. And I have a very difficult time thinking of a situation where it would be absolutely necessary in a non-parent visitation case to go to the courthouse. So you really shouldn't go to the courthouse. So your options are two. You can go online if you're able to print and download. You can simply Google New York Family Court Forms, and you'll see this option right away. It's up. You could write it down, but it's just as easy to Google it. It's a website that gives you all the forms for family court. If the child and his parent, if the parents of the children live in New York State, it's a general custody petition. If one of the parents lives outside the state, it's a different petition. And we can help you with that on the phone line if you want to call into the LP and get some assistance. You can also call the court and request a copy of the petition be mailed to your home. The number for Erie County Family Court is there. I got permission from the chief clerk to give this number out, so I'm not bypassing anyone's authority and giving this to you. But you can call the court and you can explain that you want to file for visitation of your grandchild. Mom and dad both live in New York, or mom lives in New York, dad lives in Pennsylvania, and they will send you the correct forms along with an instruction sheet on how to file those papers. Typically, you would either file by mail, or there is a website that you can upload your papers to if you're able to scan and download, and that instruction sheet would come from the court. If you don't get your papers from the court and you want more information, again, you can call our helpline and we can try to walk you through the process of filing that way. Okay, so you want to draft your petition for visitation and make sure that it doesn't get kicked out. I get a lot of clients calling the helpline saying, I filed 3 times already, and they keep sending it back saying I didn't do it right. You must have a separate petition for each parent. And if CPS brought the case against mom and dad, you also need to petition against them. So if CPS has brought the case, it's in family court on a neglect against mom, you need to file against mom, you need to file against dad, and you need to file against the Department of Social Services. You must have the address, or at least the last known address for each person you're filing against. You need to, in the section where it wants to know what you want and why you want it, you need to first describe how you have standing. So my child has sadly passed away, or the parents are not allowing me to see the child despite being closely bonded with my grandchild, and they have no legitimate reason for preventing me from seeing them. So first you describe that you have this idea of standing. Then you need to describe how it's in the best interest of the child to spend time with you. And this can be something simple as, I'm a loving grandmother and want my child to know about our family history and be part of our lives. I will not interfere with parenting. I simply want to spend time with my grandchild, and have a loving relationship. So that sounds like a lot. I know I talk fast. I hope I'm not talking too fast today, but that's a lot of information. So please remember as I said in the beginning, VLP's mission is to help people have access to justice, even if you can't afford to hire an attorney. So you can call us and we will work with you on making sure your petition is what it needs to be. This is the Family Court Help Desk line. It's 823-3255. You can call Monday to Friday from 10 a.m. to 2 p.m. It is an answering machine because we get so many calls. You leave your name and your number and a brief description of your issue. We will have a law student intern or a paralegal call you back that same day. They'll ask you some questions to make sure that your household financially qualifies for our service. Since we really are trying to reach as many people as possible who are low income, we try to focus who we help to people who financially wouldn't be able to ask an attorney for advice and have to pay. After you finish up that paperwork with the intern, they will let the attorney know, and an attorney will call you back the next day. If it's an emergency, which it most likely wouldn't be in a visitation case, but could be in a custody case, we could call you back the same day as well. Okay, so you get your petition and you file it and you're in court. You should know that right now, family court, because of COVID, is pretty backlogged. So because of that, the assigned counsel program, who represents parents on custody and visitation concerns, has extended their representation to people regardless of their financial need. So if a person who's a parent files a petition, or if they are named as a respondent on your petition, you're filing against them, they will automatically at the first appearance get an attorney. So it's really to your benefit to try to get an attorney to help you through this process. VLP may be able to represent you in court, and I really wish I could represent everyone, but we're limited as far as how many people we have that can do this work, and we want to take the cases where we can do the most help. So we limit what we do to non-parent cases. Just aside, we represent paternity petitioners, and we also can represent some people in child support cases on a case-by-case basis. Again, our full representation, even more so than our phone line, we only help people for the majority of the time who are from low-income households. So it's not just one person's income, your income, it's your household's income. So if you're living with your sister and you pull and you're sharing the home, we're going to look at your sister's income and your income when we decide whether or not you're a low-income household. As I said, we look at the financial need, but we also have to look at the merit of the case. If you clearly don't have standing or there's clearly an issue with your case, we may not be able to represent you. We also have to look at whether or not there are conflicts. As I said before, Vanessa Geit and I have spoken with over 900 people on the phone since March. Before that, I was at the Family Court Help Desk in Erie County, and I had a 10-year practice as an attorney for children and an attorney with the assigned counsel program. So there is a chance when you call that Volunteer Lawyers Project, or that I personally have worked with one of the parents on a matter related to the same child. And if that's the case, we wouldn't be able to represent you. We'll try really hard not to just leave you hanging, and we'll try to find you someone else that can assist you. And we can give you references or referrals to other agencies that might be able to help, or always to the Bar Association's lawyer referral service if you might want to at that time hire an attorney. Okay, so what's going on now with COVID, and how is that going to affect your ability to get relief? Family court on March 17th had to slow down completely. The pandemic was out of control, and they started to only hear matters that they thought were essential. Because of that, they didn't start hearing non-essential matters till the summer. And by non-essential matters, I don't simply mean it's not that important. I mean things that they didn't define as essential. They kept hearing order protection cases. They kept hearing cases brought by CPS, but they stopped hearing cases of custody and visitation. So you can imagine how backlogged they were for a while when they first started seeing these non-essential cases again. So there is a backlog. The court told me earlier this week that right now cases that are coming in today are being calendared with the court for January and February. Hopefully that will pick up now that assigned counsel is representing all parents, but there's still that just lot of cases that came in during the pandemic. You don't have to worry about going to court, and you might be afraid. I might file a petition, but I'm afraid of going to the courthouse with COVID. Most of the appearances are virtual right now. They're done by phone, and they're done on Microsoft Teams. And if you have an attorney, obviously will help you with being able to appear. These cases can be handled in a way where your final resolution is done on consent. So maybe you go to court, you file the petition, mom and dad realize that when you're in court that maybe you are going to win this case, maybe they can't use this to hang over you, to get control over whatever other issues bothering them, and they might consent to you having some type of access. You may also have to go to trial. And if you go to trial, that's when you're going to need things like the text messages and the photos to prove your case. There's also mediation, which has been a great resource to the court right now. Mediation means that you and the parents of the child will sit down virtually now with COVID with someone trained to help people come to resolutions and see if they can work out an agreement between the parties so that this case doesn't have to stay in court and instead you can come up with an agreement on your own. So what does grandparent visitation look like? What will happen if you are successful? You do everything right. You allege that you have standing in your petition so the court understands that. You go to the next part, the court thinks this is a really nice person. I think this grandparent should be in this child's life or the sibling should be in this child's life. What kind of access are you going to get? People don't like to hear this, but it's the reality. Typical access for a grandparent, especially if there's living parents, is once a month for an overnight maybe. If the parent, one of the parents is deceased, maybe 2 weekends a month, maybe a Saturday overnight to Sunday twice a month, maybe at the end of the month, a Saturday overnight to Sunday and a dinner time with the child earlier in the week. That's what the court would likely order. You can consent to a lot more. I mean, if mom and dad say, okay, I work on Thursdays, so you can see the child every Thursday and you can have one weekend overnight a month, that could be your outcome. But as far as going to court thinking that I'm going to go to court and I'm going to get an order like dad would, I'm going to have every other weekend, Friday to Sunday, I'm going to have half the holidays, I'm going to have a month in the summer, that's very unlikely. A week in the summer, that's possible. I've had that happen a lot, but a month in the summer, probably not. So you can't expect there to be a lot of access ordered, even if you are successful. But what I do find is no matter how these resolve, whether it's by consent or by trial or mediation, when you add the words additional access as agreed and arranged, and that parent has an order in front of them that says, you know, you can't hold the child over grandma or grandpa anymore. They're going to see the child every third Sunday or every third Saturday overnight to Sunday, and they're going to have every second Tuesday for dinner. Suddenly they loosen the reins. They start to realize the value of the grandparent being in the child's life, the resource that they are, and they start to give their grandparent more time. And I don't think I can think of any case where that didn't happen after a while. I'm sure there are times when I haven't heard, but the majority of the time, even in the pendency of the case, even when the case is going on, the parents start to loosen up and start giving their grandparent more access. So are there any questions out there about visitation? I think I covered the law that you would need to know. Did we get any questions in?
Lori, we did. So one of the first questions was, what does success look like for family members or grandparents, or even other family members, such as like aunts or uncles that are trying to get visitation access?
So what does the success look like, did you say?
Yes.
Okay, so what I just said, unfortunately, aunts and uncles, and I have one case in my mind that was so heartbreaking sitting in front of me at family court because they were the only part left of this child's maternal family, and there's just no way under the law that the court can order them any access. So there is no success if you're not a grandparent or a sibling. Success for a grandparent or a sibling, and I work much more often with grandparents. I feel much more comfortable talking about that. But success for a grandparent would be to get an order that said you have overnights every third weekend, and you have dinner every first Tuesday, and in the summertime, you have the right to take the child for a week to go on vacation. That would be a successful outcome. Adding the language and additional access is agreed and arranged. Now, does that mean that's all I've ever seen happen? No, I actually had a case, and I was just shocked by it, where the attorney for the child advocated strongly. There wasn't a fit parent in this case. The parent had a lot of issues, had housing issues, where my grandmother had access ordered to her every Monday to Friday. She was the one who put the child on the bus, she took care of him every night, and mom had access on weekends. Now that was a really unusual outcome. That's not typical. I've also had a grandmother who lost her child get every other weekend from Friday to Sunday, additional as agreed and arranged, and that the kids could decide if they wanted that additional access, and the kids were teenagers who wanted to spend time with her. But in that case, again, there was a question as to the fitness of the parent. And also this parent was very good at upsetting the judge and letting the judge know over and over again that they didn't respect the judge's position or opinion. So, I mean, those were extreme cases where the grandparents got more than I would typically see. But I would not go into a grandparent visitation case thinking I'm going to share holidays and I'm going to get the same kind of access schedule that a dad would have, especially if your child is alive. I want to say this too. I don't think I said it before. When we talk about standing, part of it is that the parent is stopping you from seeing the child. Not that the parent is stopping you from seeing the child the way you want or as much as you want. So if mom, who used you as a babysitter, and I shouldn't say used, but you kind of feel that way sometimes, use you as a babysitter and you babysat this child for the first 5 years of their life, all the time, you had them Monday through Friday, and now mom is saying, well, now the kid's in school and I don't want to deal with this. So if you want to see the child, you can come over here for dinner on Thursday night and you can see the child then. She's not preventing you from seeing the child. It might not be the kind of access you like, but she's not preventing you. So the chance of you having standing in family court is going to be limited based on the fact that she's not keeping you from the child. I mean, there's an argument that I would try to make, but I don't think I would be successful. Any other questions?
Yes. Should a grandparent look for an attorney for the child of interest if they're wanting to petition for visitation rights?
Should they reach out to the child's attorney?
Should they look for one, not for themselves, but for the child?
They don't have to, and that's the wonderful thing about family court in New York State, is that every petition that comes in, that child gets an attorney for the child to represent them. And they want to continue that relationship for the child. So say mom and dad were in court before and they had an attorney for the child appointed, that same attorney for the child will likely be reappointed when you bring a petition in. So you don't have to seek it out and you don't have to pay for that attorney. The child will get one automatically from the state. So if you have a 14 or 15-year-old who really wants to spend time with you and mom and dad are just, mom or dad or both are making it really difficult, and you file your petition, that child will be able to tell their attorney what they want, and that attorney will advocate strongly for what they want.
Thanks, Lori. That actually answered the next question, which was regarding at what age can a child advocate for themselves to have grandparent rights and
And
access?
that's really hard. That is such a hard question because like I said, I was an attorney for children and I took as much as I loved it, I didn't like it because it felt like so much responsibility because I had to determine when that child had the capacity to know what they wanted. And there are times when you have a little 8 or 9-year-old who's, just a little firecracker who knows exactly what they want and they can articulate to you why they love grandma, why they want to spend time with grandma. And unless you think grandma puts them in imminent harm, you're going to advocate for what that child wants to be with grandma. Same thing if that child comes in and they're 8 or 9 and they say, I don't want to go to grandma's, it's boring, she doesn't have video games, whatever their reason is, and that's what they want, and they have legitimate reasons. Whether or not I agree with their reasons, I would have to advocate for what they want. In another situation, I could have a 12-year-old who maybe has some learning issues or maybe has been so poisoned by the parent against the grandparent that they can't make a knowing decision. In those cases, I would have to really examine whether or not I would substitute judgment. If I did decide to substitute judgment, I'd have to let the court know that my client is telling me that they don't want to see the grandparent, but I'm going to substitute judgment and argue for them seeing the grandparent. This comes up a lot more in cases between parents because the court is really trying to make the right decision for parents. But if a grandchild really doesn't want to see a grandparent and they're a little older, again, it's an uphill battle. But typically kids want to be with their grandparents from my history.
Yes. Thanks so much, Lori. Those are the questions we had regarding this topic.
Am I doing okay on time?
Yes, great.
Good, because I love to talk. As you can tell, that's why I became a lawyer. I was a teacher first and now a lawyer because this way I can talk and I have a captive audience. Okay, so the next thing we're going to talk about is non-parent custody. So when I said in the beginning that only certain people have standing, and that's grandparents and siblings, to ask for visitation, anyone can ask for custody. A neighbor can, a teacher can, a counselor can, anybody can ask for custody of a child. And that's kind of like, why? Why would a loving aunt not be able to get visitation, but the neighbor 2 doors down can ask for custody of my niece or nephew? And the reason is it's really very, very difficult. And I have in the bottom, very high bar, really difficult for someone to get custody away from a parent of a child. There's a legal presumption that parents should raise their children. And if they're not going to raise their children, if you're going to come in as a non-parent and say, they shouldn't do it, I'm going to do a better job, I should do it. You can't just say, I'm going to do a better job. You've got to do something. And there's a famous case called Bennett v. Jeffries that shows extraordinary circumstances. You got to show that there's neglect, there's abuse, there's abandonment, there's something really seriously wrong with the parents, not just one parent, but both parents, that makes it where they should lose their given right to raise their child. The burden of proof is on you. If you bring the petition in family court, the burden is on you to prove that this extraordinary circumstances exist. Now, before they even look at what's better for the child or where would the child be happier, you first have to show that there's something really wrong with mom and dad. One of the things that is common, not common, but that can be used and that automatically does create extraordinary circumstances is if the grandparent's been raising the child for 24 months or more. So for the last 2 years, you've been raising this child, and mom and dad, they might pop in now and then, but they've taken no responsibility for decision making. They're not going to parent teacher conferences. They're not going to doctor's appointments. They just don't get involved. You know, maybe it's your daughter and she's just young and silly, and she'll come in and spend a half hour on a Sunday and then disappear for 2 weeks. Well, she's abandoned that child to you. If it's been 24 months, you automatically have extraordinary circumstances. And then it would go to a best interest test to see where the child is best off, with mom or dad or with you. I want to advance and I sometimes can't get that up. I'm sorry. Thank you. So there are two situations where we typically see people that aren't the parents of the children coming into court and asking for custody or not visitation, custody of the child. The first one is when the county brings the case. And I think you may be familiar with this, and it's a really stressful time in a family's life. Basically, something's going wrong in the parent's home, and CPS is called to come out and investigate what they believe could be abuse or neglect. Now, that call can come from anyone. It can come from you. It can come from a grandparent. It can come from a relative. It can come from anyone that's a mandated reporter. Maybe the child's not going to school or doing their work for a long, extended period of time. Maybe they go to the doctor and the doctor notices signs of abuse and they call CPS, but something triggers CPS to do an investigation. If CPS goes out to the home and they feel that the child is not safe in the home or that they need to take over custody of the child, the Department of Social Services will then go and file a petition in family court. Then it's up to the Department of Social Services to prove abuse or neglect. So if you go into an abuse or neglect case in family court, you'll see that the person from CPS is there, the caseworker is sitting there as the petitioner. They're sitting there just like a mom or dad would be. And the county has an attorney that's going to be representing that petitioner, CPS. And they're going to be putting on a case saying that mom or dad or both are neglecting or abusing the child. If the child, sometimes they keep the child in the home and they put all kinds of services in place, and they make sure they keep checking in on the parents. They keep going back out and interviewing and making sure that the kid is safe. But very often they remove the child from the parent's home. When they're going to remove a child from a parent's home, the Department of Social Services is to look for a suitable relative to take custody. And they call that kind of custody 1017. So you may have heard the term before of a 1017 custodian. And what's the number mean? Well, remember I told you there's the Family Court Act. It's not that big. And Article 10, Section 10 of the Family Court Act deals with cases brought by the county. And 1017 is just the number that defines what a 1017 custodian is. So the 1017 custodian, Department of Social Services probably wouldn't agree with this definition, but that's how it looks to me and how it feels to me, is the 1017 custodian is almost a babysitter for the county. The county really has custody of this child and decision-making for this child, and the court is going to be part of those decisions. And the 1017 custodian is the person that they place to take care of this child, keep them in the family while they figure out what's going on with mom and dad and whether or not mom and dad are going to be able to get back to a place where they can be the custodians of the child. The 1017 custodian can on their own file for custody of the child. They file under a different part of the Family Court Act, which is Article 6. So you might hear Article 6 custody, and that's the typical kind of custody you think of when mom or dad files for custody or grandma files for custody. It's not when the county is involved. So the 1017 can actually ask the court for custody once this case is happening. If no suitable relative is available, the Department of Social Services will use foster care. Now, when I say suitable relative, what do I mean? If the county is looking to place the child, they come and this happens fast and it's confusing and it's upsetting for the family because, you know, this is your child who's being accused of abuse or neglect. If you're the grandparent or your sister or your cousin, and you might not even think they're right. You think, you know, they're having some problems, but they shouldn't have the kids removed from their home. And it happens fast. They look for a place to place the children. They'll look into the background of the people they're considering placing the child with. So if you yourself have a history of Article 10 where the county came in and removed children from your home, they're probably going to pass and look to another family member or relative. If they call you and say, would you take this child in? And you say, I can't take in a 2-year-old. Or what happens often is, I don't want to do that to my daughter. My daughter's gonna be so mad at me if I say, yeah, let the kids stay with me. And you pass on being the 1017 custodian and they can't find someone, then again, they put the child in foster care. And we're going to talk later about why you really want to try to prevent that from happening. And again, I have the utmost respect for the foster care system, but it's not what I would ever want to have happen to a family if I could keep the child in our family. Even though it could be a very loving foster relationship, it's just not the best thing for the family. Okay, so what happens on the other side if the county's not involved? And that would happen when a person in the family is concerned about the well-being of a child. Their CPS isn't involved for some reason. Maybe you don't want to call CPS because you just, you don't want to deal with it. You just want to take care of it as a family on your own. Or maybe CPS comes out and investigates, but the child's staying not only with mom who's got issues, but with you. Maybe you live with mom and you think mom is abusing or neglecting the child, but the child is safe because they're under your care. So CPS says, we're not going to bring this into court right now. In those cases, you can bring the case into court. You do that by filing a petition in family court. You, again, because the county's not involved, you're the person who's going to have to prove those extraordinary circumstances. And the child will remain with the parent unless the court orders that the child temporarily reside with the petitioner or you during the case. So they're not going to give you custody right off the bat when you go to court at your first or second appearance, but they might say, I think this child should be staying with you temporarily while we figure out these facts. Your allegations seem pretty strong. Please know that if you go on your own because you don't want to contact CPS and there's a lot of issues going on in mom's home or dad's home, the court themselves can ask CPS to intervene. So if you file a petition in family court and you make strong allegations, which you're going to need to do if mom and dad don't consent to you being the custodian, and the court looks at it, it's not like CPS isn't going to get involved. The court could order an investigation on their own and ask CPS to look at what's going on in mom and dad's home. Okay, so I want to talk about cases because these are the more difficult ones to prove or to win. Well, the cases where the county's not involved. So here's two different scenarios, and I think they'll give you some context as to, oh, I got scenario one twice, so apparently I was tired when I typed this, I apologize. But two different scenarios that will talk about what situations look like and when you're going to be successful and when you're not. And I think it's good. I think the reasoning of the court is good in this case. So a grandmother lost her daughter. The grandchild's father is raising the child. Grandmother believes dad is not doing a good job and that she could do much better. She also believes that her daughter would have wanted her to raise her grandchild and not dad. The father works long hours and the child is in before school programs and after school programs. Dad lives in an apartment in a poor area without a nice backyard, and it's just not the best place to live in a low-rated school district. The child stays at dad's mom's house every Saturday night because dad's still young and he wants to go out on Saturdays. But overall, dad is taking care of the child's basic needs. Child's going to the doctor, he's going to school, and dad loves the kid. Grandma, on the other hand, though, is a retired former school teacher. She lives in a beautiful home in a top-rated school district. The child loves her and loves being at her home. Grandma wants to petition for custody of the child because she knows she can do a much better job. She can be there and take care of this child. Will she be successful? After trial, likely not. I can't tell you for sure because it's all going to depend on how the facts bear it out and whether or not you can prove that there's something really wrong with dad. But dad working and dad putting the child with a good babysitter one night a week, dad living in a poor neighborhood, that's not enough for someone to take a child away from their parent because the parent has this inherent right to raise their child. And again, that might sound upsetting because you think, oh my gosh, I could do so much better. I could be so much better for this child. But think about it. If the decision was made on who has the nicer house or who lives in the better school district, there's something really wrong with this world because it doesn't take a fancy house to love a child and to raise a child really well. So they're not going to look at things like who has better resources and who can do much with a grandparent. Now, if this was a case of two parents, they might start looking at things like school district and things and who has more time for the child. That would come into play, but this isn't about two parents. This is about a parent and a non-parent. So they won't go into those types of things. They won't find extraordinary circumstances. Scenario two, unfortunately, one here. A child's mother has a long history of drug abuse. And this is really painful to even read because I've seen so many of these cases and I can think about the faces of the parents in court crying and the non-parents who are taking care of the child because of this horrible addiction that the child might be going through. The child's father is incarcerated, so he can't care for the child. The mother has this history of abuse. Mom's now on another downward spiral. It's not her first. She's using heavily. She doesn't have a stable home for the child. So she drops the child off at her brother's house 3 months ago and like pops in rarely just to, maybe ask for money, maybe take a shower or sleep, peeks in at the child, but then leaves. Because he's now taking care of the child, the uncle discovers that the child has missed a tremendous amount of school and has not been to the doctor or the dentist for a while, not up to date on their vaccines, just not being cared for. The child's now seeing a counselor to deal with the trauma he suffered from seeing his mother go through the trauma of abuse, of drug abuse. Will his petition be successful? Again, there's no guarantee to anything, but yes, this sounds like a successful petition to me after trial. But you're going to have to prove all these things. You're going to have to prove that the mother has done these things. You're going to have to bring in evidence that the child hasn't been to the doctor or the dentist. What will likely happen in both of these cases, if the first one, if the father has any desire for you to be a custodian, is you could get a consent order. And in the second scenario, very likely is mom realizes more and more that she's not going to win this case, or possibly with drug addiction, they just stop coming to court. You'll either get an order on consent or an order on default, which is what happens when the parent just doesn't come to court repeatedly, and the court wants to get a resolution to the petition in front of them. Okay, so that's very different than when the county removes the child. There are two scenarios when the county removes a child. One is the county calls you up and says, will you be the 1017 custodian or the person who looks after the child while we figure out what's going on with mom and dad? And you are that 1017. Then the child will be staying with you while the court is handling the abuse or neglect case. And these cases, abuse and neglect cases, are very long. And the reason is, they're going to take away at the end, if the mother or father doesn't get everything together, they can take away their rights to be a parent. They can basically make that person a legal stranger to the child. That should not happen quickly. That should give the parent plenty of time to get their act together and to become an appropriate parent for this child. But when you're in these cases, you have two roads you can go down if you're the 1017. You can choose to start becoming a foster parent with the hopes of eventually adopting the child when the parental rights are terminated. You also can file for Article 6 custody, which is the regular custody. And if you file for that in court, you can settle the case early on with mom and dad saying, okay, they can have custody of the child as long as I can, come back when I get better, or come back when I get back on my feet and ask for custody again. The pros and cons of each, with fostering, if you foster and rights are terminated and you get to adopt the child, you have no fear of the parent coming back in and asking for custody and then getting it. There are also financial programs available to people who are fostering the child. With Article 6 custody, the pros are you get a resolution. You have that child with you. You have an order of custody. If the child's with you for 24 months, you immediately have extraordinary circumstances. So the court will look at whether or not it's in the child's best interest to go back to mom and dad's if mom or dad file again in the future. If you have a trial and the court finds extraordinary circumstances, at the end of a trial, the court will then, mom and dad can't come back in and say they should come with me because I'm the parent. They'll lose their preference to custody, and again, we'll have to go to best interest. So Article 6 custody, it's a little frightening because if I get it and I get this order of custody because I want to get this case over with, mom and dad might agree to letting you be the custodian because they don't want to continue on with the county and have the county terminate their rights. It might sound like, I don't know, that seems kind of iffy, but unless the county has an extremely strong case for terminating the parental rights, this is one way to make sure that that child stays with you and gets the help they need from you right now, and likely will stay with you in the long run. Wrong going on in mom and dad's life. Oops, can you go back?
Yep, Lori, I think your video froze really quick. Are you able to go back?
Can you hear me now?
Yes, we can hear you now.
I got a little message that my internet connection was unstable, but I'm hardwired, so I'm not sure what happened. I apologize.
Okay, we could go back to the previous slide. That'd be great.
Yeah, I'm looking. It didn't come up. The box didn't come up.
There you go.
I apologize for that.
No worries.
Am I froze again? Can you hear me okay?
Yes.
Mhm.
Okay, best interest for you to be the custodian. If you're not the 1017, the county comes in and they file immediately for Article 6 custody. I can't stress this enough. File at the very first. You're going to allege extraordinary circumstances and say why the child should be with you. You also need to file for visitation right up front if you're a grandparent or a sibling. The reason is it's not up to that 1017 custodian to decide who that kid can see or to spend time with. The county, remember, has custody of the child. The 1017, or the person they place the child with, is simply watching or taking care of them while they figure out what to do with mom and dad. So I've had cases where paternal grandmothers are really upset because maternal grandmother got 1017 and she won't let me see the child. It's not her fault. It's not her decision. The court needs to decide if you can see the grandchild and or issue an order of visitation. And without that order, the other grandparent or whoever the 1017 is isn't supposed to be allowing visitation. So you need to get that petition in right away, especially again if the child's in foster care. It's not about hurting the parents or not wanting to help the parents. You know, I can see where a child would say, God, mom, or God, dad. No, you're trying to make sure that this child does not get put in the foster care system, because once that child, and I think it's on the next slide, once that child's been living in a foster home for 6 months or more, you're going to lose that family's preferential right to raise the child. So if there's a little 2-year-old who goes into foster care and he's there 9, 10 months, and you come in then and you say, wait a minute, I'm going to file, I want custody, you know, they're not going to want to disrupt that child. He's already bonded with the foster family. And if mom and dad lose their parental rights, it's I need to progress. Can I go to the next slide? Thank you. Okay. Avoiding, and we just said this, I'll just read it. I'm going to say it again because I've lived through the, not personally lived through, but through my clients have seen the heartbreaker. The child will go into foster care and someone from your family or someone that is close to your family needs to file for custody at the very beginning. If the child parents' rights are terminated, could that grandparent then go and file for visitation or file for visitation and not custody? Yes, but think about how different it is if a foster family has custody of the child and you have visitation. What if something goes wrong during your visitation? What if your child, that maybe the order says that you can have visitation at your house, but your child who the case was against can't be there. And your child doesn't realize and comes over and the little kid goes home and says to his foster family, oh, I was at grandpa's and guess what? Mommy and daddy showed up. Well, they're going to go back to court and ask for your visitation to be stopped. Or what if something happens in your life and you have to cancel a couple weeks in a row? Are they going to go to court again and ask for your visitation to stop? Also, are they going to be at family parties and times outside of whatever visitation you have ordered? Likely not, obviously not. So you really want someone who's connected to your family, even if it's the paternal family and you're the maternal family, someone at least where you know where that child is and you have contacts so that you can keep that child in your life. Remember, tell mom and dad, I'm not trying to hurt you. I'm trying to make sure that if this goes wrong, we get to keep this child in our family. You can always, when you settle custody cases, if everyone agrees, you can always have joint custody with mom or dad. You can always build a menu into your Article 6 custody order that says if mom and dad clean up, you know, if mom stops using drugs or if dad, you know, gets the help that he needs and they want to repetition, I'll give custody back. You can always have those kinds of arrangements. It's not a grab for the child. It's a protecting the family unit. So file, file, file. Okay, how do you file? Again, where does a child live? The exact same things I said before about visitation. The only thing that's added on here is this an emergency? What if you are the brother of a sister, and you have a niece and a nephew, and you find out from the niece and the nephew that mom has become suicidal and she's threatening to harm the children. Well, that's an emergency. If you go in right now with COVID and ask for a custody petition and send it through the mail, it won't get calendared, like I said, until January or February. But there is a paper you can put with your petition called an order to show cause. And that's basically asking the judge to give you some emergency relief. Please don't put this in the quay. Please don't make me wait. Please look at what I'm saying in my petition and give me some temporary relief. Let this child stay with me. If you file an order to show cause, the judge or the court attorney referee will review it. If they feel that this is an emergency situation, they can hear your side of the case, even if mom or dad isn't present, make a temporary order, and then have mom or dad return to court in a few days to explain why that relief shouldn't be granted. But it gets you to the head of the line and it gets you in court. It has to be an emergency though. It can't be, like a visitation case. I want an emergency order of visitation because I haven't seen my grandchild, especially during COVID. Unless that child is in danger, the court's not going to want to hear it or let anyone cut the line. Only in cases where the child really needs some emergency action. And again, you get the petitions in the exact same way I said before, and please don't go to the courthouse unless it's absolutely necessary. Drafting your petition for custody, this is complicated, especially if the county hasn't filed. You want to make sure you do a really good job, especially also if you add an order to show cause. The order to show cause is one page. It just says, based on the papers attached, I want you to give me the following order. Maybe the order says, child to reside with petitioner and not to be removed from the state, because you found out that even though the child's been staying with you informally, mom who has a really bad drug addiction and a new horrible boyfriend is planning on picking up the child and taking off to Texas with him, and you're scared. So then maybe you want to go to court and let them know I need an immediate order and I want the child not to be removed from the state. But that order to show cause is only as good as the papers that are underneath it, because the judge is going to see that, flip to page 3 of the custody petition and see why is this an emergency. So you want to make sure you do a really good job alleging that, alleging extraordinary circumstances and why the child should be with you. And I say this very strongly, especially in these emergency cases. We at VLP want to help you, not just can help you, we want to help you. And the way we can help you, again, is to call this helpline number. You'll get one of us on the phone. If it's an emergency, let the intern know what it's an emergency, and they'll call one of us up and see if they can get us on the phone the same day. And we can take you step by step into what you need to put in your petition and your order to show cause. And then finally, VLP does do full representation in matters of custody for non-parents, whether there's a DSS case pending or whether or not you filed on your own, we can possibly represent you. Again, we have to look at financial need because you have to be financially eligible for our service. And we have to look at the merit of the case. Like, do we think we can win for you? Not is this an easy case? Because I don't want to take the easy cases, because if you've got a case with the Department of Social Services and you're the 1017 and everyone wants you to have custody and the attorney for the child says, file this Article 6 and you'll get custody, and it looks like everything's going smoothly, I don't want to, you don't really need me. I want to represent the people who maybe that uncle who mom's going to fight it and he needs to prove that the child is in danger in her care. I want to represent the grandparent, maybe that filed isn't the 1017, but really should have been. The kid went to foster care and this is their first appearance and they want to stop that from happening and they want to be the 1017. So it's not about merit. Doesn't mean is this easy. Merit means, can we win? Can we win? If I do my best and if the other attorneys at our firm, if we do our best, do we have a good chance of winning the case for you? And then also, again, we have to look for conflicts. And it's hard when I tell someone that I'm conflicted out because I gave mom legal advice at the help desk. But you got to realize that the same protection that mom has in telling me her story and not letting me be able to go in later and use it against her, that's going to extend to anyone I represent. So if I was to take your case and in the future, someone brought a case against you, I couldn't help them either. But like I said, if we can't help you, the help desk can give you some general advice. One of our attorneys can give you some basic advice. If I can't, because I'm conflicted out, one of the other ones can, and we can refer you hopefully to another agency that might be able to help you. Okay, again, the court process during the pandemic, family court is really at a slow pace, not to their fault. And I can't remember the numbers. When I heard them, they were just shocking. The numbers of cases that they hear on a daily basis in family court is out of control. And then you think about just stopping that line for 6 months or 3 months or whatever they had to stop it for, and then reopening. You've got that huge backlog. So right now during the pandemic, if it's not an emergency, you're not getting into court until early next year. All parents will get assigned counsel. Grandparents are not guaranteed an attorney in family court. Non-parents are not guaranteed an attorney in family court. If you're the custodian of the child, not the 1017, but say at some point in time you went and got custody of the child, then you get assigned counsel. But if you've never been to court, you never got legal custody of the child, and you're not a parent, the only way you can get an attorney is through an agency like Volunteer Lawyers Project. Again, these are virtual appearances. Don't be afraid of having a show in court. Trials could end up being in person because people have a right to have their case heard in person, but very unlikely that you'll have to be in court during this pandemic. Cases can end by consent, and cases can end by trial. So you, mom, and dad can all come to an agreement, and that can be done really quickly. A new thing that's happening, which is really great, and I'm glad I have the opportunity to tell you about, is because of the pandemic, mediation services through family court are available right up front. So if, say, mom passes away, it's horrible and everyone's really sad, but dad knows that grandma's the best one to raise the child, or grandpa's the best one to raise the child. And he says, you know what, I don't think I can do this. I want you to have the child. I want you to raise the child. Maybe I could have joint custody and visitation like I did with mom, but you should raise the child. In cases like that, you can call the court and get a referral to mediation. And you can work with this mediator and come to a final agreement, and then file that with your petition. So when you file your petition asking for custody of the child, you can attach that mediated agreement, and the court will see that we already pretty much have a decision, and then that court process will go a lot faster. I do want to say too, in cases where there does seem to be consent, where mom or dad aren't arguing with you, they know they need help, they know they can't do it, they know you can do a better job, be careful with how you make your allegations of extraordinary circumstances. You need to say enough in that initial petition so the court is willing to look at it. So there are extraordinary circumstances. The parents are unable to properly care for the child. Something simple. You don't want to go and blow up everything that parent ever did if you already have their consent, because they're going to get that petition before the decision is made. And if they say you've told every horrible thing that they've ever done to the court, they may get angry and back off. Know that you have the ability to amend your petition in the beginning of the process once by right. So in the beginning of the court process, you can, if you go into court and you think dad's going to agree and mom's going to agree, and at that first appearance they say, nope, you're not getting custody, you can amend your petition, and then you can really blow it up if you need to. But you don't want to go out swinging if you already seem like everyone's agreeing. But again, please call us and we'll help you determine how much you need to put in without putting in too much if you have a likely consent with the parents. Whew. Any questions about that? I talked a lot. Any questions about custody?
Yes, we do have a few questions about custody as well. So thank you so much, Lori. That was
Welcome.
a lot of information, but really informative. I was taking notes myself.
I know it's a lot of information, and that's why I can't stress enough. And I hope it wasn't burdensome on the viewers. I can't stress enough to you to please call our helpline. I mean, you might get me on the phone tomorrow. I'll go through it with you again. All of our attorneys, Vanessa Geit and I, are both more than willing to talk about your legal issue and the specifics of your case and go over the things I talked about today.
So one of the questions was, if there's a circumstance where a non-biological family member received legal guardianship and there's been more than 24 months of abandonment, what would be next steps for them if they wanted to pursue legal adoption?
Okay, that unfortunately is a surrogate's court question. So once a guardianship is surrogate's court, custody is family court. So in family court, you would file for custody. And if you had sole custody of the child and parents had visitation, but they didn't really see the child, there wouldn't be a strong push for you to try to get adoption. They're not going to terminate the parental rights based on your desire. As far as what would happen in surrogate's court, unfortunately, that's not my area of expertise. At the end, Galena is going to put up the number for Volunteer Lawyers Project and our general lines. You could call our general line and talk to an attorney that specializes in surrogates, or not specializes, but focuses their practice on surrogates court. I'd feel much more comfortable making sure you got an answer from them. It's kind of like, it's not as, I don't save lives, it's not being a doctor, but I always use that analogy. You know, I know about the heart, I don't know much about the brain, although I do know that they interact together. So even though I do understand surrogates court issues, I would feel much more comfortable if one of our surrogates court attorneys spoke to you about that issue.
Thanks, Lori. And one additional question was, do family members or anyone who has care of children, are they allowed to travel out of state and out of country without parents' permission?
Well, that's going to depend on the kind of custody that they have. So one of the things I talked about before was sole custody and joint custody. When a person has sole custody, they're able to get a passport for a child. If a person has joint custody, you typically need to have the other custodian sign off before you can get a passport. And there's more to that, which again, I would suggest that you call our helpline to get more into how you can get a passport if it's being unfairly held back from you by the joint custodian. But with sole custody, you could make that decision. These orders that are issued, though, are going to have, are often going to have, additional factors. So you might get an order that gives you custody, but it could say in there that, the mother and father get visitation with the child every other weekend or every weekend on certain times. And if you're going out of the country is going to stop that from happening, then you have to petition the court and ask for a change of the order that would allow you to travel out of the country with the child during that time. Also, some orders even say the child is not to be removed from the country. If you're the 1017 custodian, you can't do anything without the approval of the Department of Social Services. So if you don't have an order, a final order of custody, you have 1017 custody, everything you do needs to be cleared through the Department of Social Services first and the court.
That was our final question, Lori.
That was the final one?
Yes. We had a lot of interaction though from our Facebook attendees. We have gotten some requests if this information can be shared out. So Lori has stated that we can share the PowerPoint information with everyone who's joined us. We had some people join us a little late. So this session is available on our Facebook and will also be available via our Say Yes Buffalo YouTube page. As Lori mentioned, there is a hotline for families to contact, so I'll share that with everyone now. So if you do have additional questions regarding everything Lori shared today or others related to housing, divorce questions, unemployment benefits, here is the information for our Volunteer Lawyers Project hotline that anyone can access during this time. Lori and Emily, I'll leave it open to you to close this out if there's any additional information you would like to share.
I did just want to caution Galena, and I apologize. Just if it is going to be shared, the information, I absolutely have no objection, but I would want to have that approved by my supervisors first. But as far as people watching it on your site, I know Volunteer Lawyers Project will put it on our website as well. So it will be out there for people to watch. But as far as actual use of it, I think I would need to get approval from the head of our agency or one of my bosses.
Great. Thanks so much, Lori.
You're welcome. And I want to say to everyone out there, thank you so much for listening to me. I know, as my children will tell you, I go on and on and on sometimes. I know it was a lot of information. I want to get as much information to you to help you make the best decisions that you can make regarding your family. And as I said before, Vanessa Geit and I and the attorneys at VLP are here to help you. We're here to answer your questions. And I look forward to speaking with you on the helpline if you need that level of help. So thank you. And I guess I'm going to close it out.
Yeah.
Thank you again. Goodbye.
Thank you, Lori.